Good evening, Mr. Hindol Sen Gupta. Thank you very much. My first question, Mr. Sen Gupta, how do you look at what's happened at the court? Let's just start from that. It's the same question that I asked the earlier panelist as well. Mr. Faizan Mustafa, it's to you as well. How do you look at what really happened in the court? 56 years on, there's still a decision to be made on the minority status of Aligarh Muslim University.
I think what we should do as a society is to step back for a moment and contemplate the issue beyond one judgment or one decision or one argument. The question that we really should ask is 56 years, as you said, after the initial decision, so to speak, we are still debating this question because more than 75 years later, we have still not been able to decide what on earth is a minority institution. Why ought India, contemporary India, have something called a minority institution? Why is it that certain sections of the population should feel so, in a sense, insecure that they must have their own unique institutions, especially in education? I can understand they might have religious institutions, which are absolutely fine. But in education, especially, or health for that matter, why must they have special institution that requires special legal safeguards? That makes no sense. What is being preserved in an educational institution, especially for a minority population? That makes no sense. Logically, if you think about it, 75 years on, it makes no sense. These safeguards were provided at a particular time in a post-colonial country, which had seen, in a sense, communal violence, which had killed more than 1 million people during partition. And therefore, post-colonial India decided that certain communities and minorities required certain protection so that this kind of violence, this kind of conflict does not flare up again. But we are far, far away from that moment. We are in a point where Muslims are the second largest majority in India. They're not a tiny minority population. You cannot say that, well, they're like the Parsis who have extremely unique things that needs to be protected. And the numbers are so small that this protection is justified. Right? India is one of the largest Muslim populations in the whole world. So these kind of protections, whether it's for Muslims, whether it's for Christians and other groups, which have really populations in millions of people, has no bearing in contemporary India. Contemporary India should really focus on quality rather than go into this sort of protracted debate again and again. Because as you were saying to begin with, there in fact will not be 10, 20, 30, 40 years later, again there will be another issue about like this. Again, there will be a court case and some other judgment will come.
So, Mr. Hindol Sen Gupta, while you're arguing that minority institutions are not relevant to contemporary India education institutions, as you were arguing, let's just look at what the court said about Article 30. It opens up a very, very broader interpretation of a constitutional right given to the citizens of this country.
Many of these things, whether it's the AMU case, whether it's the Waqf Board case, many things like these are inherited problems, right? And now, these, obviously we go back to certain sections of the Constitution and, we pick them up and say, well, this is defined because of this particular, section, so to speak, which is why many of us argue that perhaps in many senses, the Constitution itself, which we inherited, which we, got from our forefathers, which in fact was largely borrowed from the Government of India Act, and therefore has, was a continuation in a sense of the colonial system, in large parts needs to be re-understood, re-examined and re-looked at. Now, the moment you say that, there is an uproar in this country, all kind of issues come up. Someone will come and say, no, this is basically a subterfuge for taking away all reservations.
Okay, No, while you're making this argument, I also, allow me to bring in that question of Article 30 again, because let's look at what the Supreme Court has said. Supreme Court, I think the interpretation has become so much more broader. The Supreme Court has said it's, the minority institution may have established or can establish, minorities may or can establish institutions, but they don't have to be administered by minorities alone. That's literally a very broader spectrum of definition of Article 30 that has been done till now.
In my opinion, what the court has done is taken one more step towards, in a sense, validating what somebody like me is saying, that, well, look, actually, these institutions, even if they're so-called minority institutions, if they can be governed, in a sense, in the broader framework, which is universal for every citizen, which is universal for all institutions, including governed by, non-minorities, so to speak, that takes the argument one step further, in a sense, to try and understand or try to, argue that maybe such institutions do not require this kind of privileges which were once provided for certain, particular circumstances today anymore in contemporary India. I think the court has really taken one more step, towards the final goal that I'm painting out.
Mr. Sen Gupta, let me ask you a question that I asked my earlier panelist as well. It'll be, for example, that as a layperson, when you're looking at the governing, at the administering or the functioning of minority institutions, you have AMU at one point where, of course, whether it's a minority institution or not is to be decided, but you have other institutions, say, for example, St. Stephen's, that is part of Delhi University. Now, the earlier panelist said that at the heart of, it is also about recognizing, acknowledging that an institution is a minority institution. But how do you look at the heart of this debate?
You, I'm sure, undoubtedly know that these questions have been raised, including in legal terms, also about the admission procedure at St. Stephen's College. This has been in the news for several years now. In fact, certain student bodies within the St. Stephen's College, who were students who studied, alumni of the college, have in fact been embroiled in this sort of legal taking on the college and its procedures, especially in admission, which tie back on the minority institution question. Again, St. Stephen's is regarded as one of the best known top colleges in the country. Some of India's most important people in almost every profession, whether it's government, whether it's bureaucracy, whether it's diplomacy, have come out of St. Stephen's. Now, does that organization need to remain under this sort of minority umbrella and receive particular, protection, which allows it, especially in the admission cases that I pointed out, create anomalies and bend the rules or twist the rules, which allow only certain kinds of people to get privileges as far as admissions is concerned, is once again a case which forces us to confront the point that I've been belaboring again and again for the last few minutes. What is the role of this kind of privilege in contemporary India for such institutions, whether it's Muslim, whether it's Christian or any other?
But Mr. Hindol, it's also important to see how the Supreme Court has given out its verdict today. The Supreme Court has made a very, very important verdict, and that is it has overturned the judgment that was given in the 1960s that said that Aligarh Muslim University is not a minority institution. And the Supreme Court went on to overturn that judgment. So that in itself is significant when it comes to the right of minorities or the recognition of minorities, not for AMU, but for the larger debate, as it were.
I think, these things always get dismantled in steps, so to speak, right? And I think from my understanding, this has been one more step towards dismantling the framework. I think you're asking me questions about one particular case, and I'm trying to explain that essentially the judgment takes us a step forward into dismantling this framework of thinking, this entire, a sort of structural pattern, as it were, in our policy making that looks at certain kinds of privileges provided to certain kinds of institutions on the basis of a particular kind of communal idealism that perhaps had some importance when the country got independence after partition and the bloodshed it saw. But today, in contemporary India, I want to reiterate, perhaps has less importance than ever before, especially because of the kind of institutions that we're talking about and their importance over a 75-year period.
My last question, Mr. Hindol, there is a constitutional mandate, and the constitutional mandate in terms of the rights of minorities, whether it be about their institutions or other aspects of minorities is also very, very clearly laid down. The mandate is rather clear in the Constitution as well.
That's why it's still continuing. I mean, because it exists, because the framework still exists, this status, as it were, is being utilized even today by these institutions. So, that's a logical extension, right? But should it be used? Should it be there? I think these are all valid questions.
Well, Mr. Hindol Sen Gupta, thank you very much for your time, interesting perspectives. And as we have been saying, this discourse around the minority status of Aligarh Muslim University and the way the court has approached this case is not only about Aligarh Muslim University, but also has larger, broader contours on India and how India looks at this entire issue. Thank you very much for joining us. It's time for a very short break. On the other side, we'll bring you all the latest.